Hi, everybody. First, I want to quickly acknowledge for those who are watching live, acknowledge and just hold in our thoughts the folks of Southern California who are experiencing some tremendous loss right now due to the wildfires. So just want to call that out and hold them in our thoughts. My name's Adam Flaherty. I co-host a podcast called Modern Dadhood. It's a parenting themed podcast, and I'm excited to welcome Becky Lessard, legal counsel, trademark attorney. But before I ask Becky to introduce herself and share a little bit about her background, I just want to give you a little bit of context about how Becky and I met and how this webinar came to be. So my podcast, again, Modern Dadhood, it's always been a passion project. We're about 5 years in, and about a year and a half ago, we had a guest on the show who was a young mortician, and we had this really interesting conversation about fatherhood and raising his children, bringing them to work with him occasionally in a funeral home. It opened up a lot of questions and some really great discussion. But at the end of that conversation, my co-host Mark and I pitched to him. His name is Victor. We said, you really should do your own podcast because I think you'd have a huge audience for this. And Victor agreed. After several weeks or maybe months of discussions about it, he agreed to do it. And so Mark and I started to put together a concept to kind of pitch to him, and some artwork and a trailer, and created this real proof of concept with the idea that we were going to take it to some networks and see if we could arrange a distribution deal. And I knew that it would be important to networks that we had already kind of confirmed that there wasn't going to be a conflict with this name and this word mark. I happen to have a friend who's an awesome patent attorney, and he connected me with Becky, who's an associate of his, who's a trademark attorney, and she navigated me through that process. Thankfully for us, it was very smooth, but really I became interested in that process and how valuable it can be to podcasters in particular. So with that, I'm going to turn it over to Becky. Becky, you can go ahead and introduce yourself. And I think we'll just have you start by giving an overview of trademark law as it pertains to all of us as podcast creators.
Sure. Thanks for the intro, Adam. As Adam said, I am a trademark attorney at a law firm in Portland, Maine. I've been practicing for over 10 years, and I've only done trademark law, so this is my area of expertise. I'm very excited to educate the TPA community about trademark law because it's incredibly important and it's sometimes an overlooked aspect of launching a podcast. So I think the way that I'm going to kind of introduce trademarks to you all is just go through the three basic concepts. First is the United States is a use-based system in that you get trademark rights just by using that mark, not by registration. So if you have a podcast with a name that you've been using for a while, you have established trademark rights in that name, regardless of whether you have a trademark registration for that. So there's a lot of confusion about whether or not you need a registration in the US. You don't. It adds additional benefits, which we can talk about later. But just know you do have enforceable trademark rights once you start publishing those podcast episodes under that name, which is great. Second, before you launch any podcast, any large project, you always want to do clearance, whether or not that's with, just a quick internal search, or, as I would recommend with a trademark attorney, to make sure there's no conflicts to your use of that name. Because the last thing you want is to launch your podcast, put out a couple episodes, have a lot of people love it, and then get a letter from a third party saying, you're using our trademark, please stop. And that's one of the first process that Adam and I went through when we started working on his new project. So clearance is huge. It can, make things a lot smoother and eliminate some issues that might happen down the road. And finally, registration can be a really important part of your trademark plan, particularly if you're looking at a larger project that you want to get distribution deals with, or that you plan on, making it a very visible project. That registration can add, make it a more desirable property to people who might want to invest in it or distribute it, and also it gives you, more teeth than any sort of cease and desist letter you have to send out. Does that, Adam, does that,
I think
give
that was
you a good
great.
overview?
Yeah. So I do want to bounce back to the first thing that you said,
Please.
because it's interesting that, so unlike an invention that someone comes up with, where people say you don't have to patent this or copyright it, you just mail yourself a copy of your plans, and you keep that sealed, and that's dated and authorized, and that that serves that you had this idea. For unlike any of that, with a podcast, as soon as you publish it to a platform, it's out there on the internet and it's associated with a date. And so if anybody said, well, no, I had this idea first, you can say, well, no, I published this first. But if, let's say, a large network wanted to produce a podcast in-house and they wanted to use that name, and they went through the formal trademarking process, can you share with the attendees like how that could play out? You came up with the
Um,
idea first, but they went through the process of trademarking it, and now there's a conflict with these two entities with the same name.
okay, yeah. So third-party conflicts do happen a lot in trademarks, and they're never fun when you're on either end of that, because it's time and money and resources and a lot of stress, particularly if you're defending your rights. So there's a concept in trademark law called priority. The first to use it has superior rights. So in this scenario, um, you, the independent podcaster, started using the mark before large company did. Um, but large company applied to register the mark and has registered rights. Their registration still doesn't trump your prior use. They can try to threaten you, etc. And if they do, that's a good time to pick up the phone and call a trademark attorney, um, because they don't have superior rights to you despite the fact they have a registration. What really comes down to is who used first, not who registered first.
That's helpful. That's helpful. So I wonder, like I said at the beginning, my main project has just been something that we've treated as a passion project, and we've grown it organically, and some amazing opportunities have presented themselves as part of growing it organically. But with this project that I engaged with you on, it's something that we again intended to create a proof of concept and then start shopping it to some networks. So totally different approaches that we're taking with each project. And so at what stage, if somebody's in that first camp where I've talked about modern datahood, growing it organically, we don't necessarily intend to make it a business. If at some point down the road a network expressed interest in partnering with us on it, like, wonderful. We haven't gone through the trademark process with that. So for creators who are in that camp, not intending to go shop to networks, but just to grow organically, at what point would you recommend considering exploring this process?
A lot of it does come down to finances. If it's something that, you are seeing some good revenue come in from it, it might be worth protecting, that valuable asset. It might not be about money for you. It might just be a passion project that you still want to protect. You don't want anybody to kind of infringe upon your baby. You know, go ahead and protect that. You can file an application pretty much at any stage in the process, in the United States, which is great. So if you're at the initial stages like you are, you haven't launched it yet, you can file what's known as an intent to use application, which, excuse me, I have a little cold, which allows you to get your application on file before you launch. It puts the public on notice, competitors on notice, like, hey, I'm launching the Becky Lessard Law Podcast, which is a terrible title. But it lets everyone know, okay, this is on file. I have an intent to use this mark. I'm going to launch it within the next 3 years. You can also have been around for 10 years and file a use-based application. It really doesn't matter the timeline of your kind of your project's journey on when you file the application. It is good, however, to consult with a trademark attorney about strategy because, you know, at least for my practice, it's not just about getting the business, it's what works right for what you're doing. So if you have a fledgling podcast, you don't have a lot of funds, just start using it, make some more money, get an application on file. If you have the funds, great. In addition, if it's other considerations about whether or not you want to get an application on file is if this is a limited run, or if it's only going to be like, 10 episodes, you're not going to invest a lot in it. No need to put an application on file for that. No need to register it. Really, your trademark application should follow the value of the property that you want to register. If it is your flagship podcast, if it is your production company name under which you're going to be, producing in-house and, third-party podcasts, definitely get the production company name registered if that's kind of your big brand. Really follow the money almost.
And I'll just say, in my own experience, for me, it was worth investing the money. And we can talk about the sort of financial implications of doing this shortly. For me, it was worth investing the money to work with you on it, specifically because you've gone through this process many times. I haven't. There are things about the application that I wouldn't be confident that I was doing correctly. And I wanted to get it done, give it the best chance of being approved when it gets to the review stage, and not have it kicked back. So it was well worth it. And you were a pleasure to work with, if I can just give a quick testimonial. But I do know that this is something that people can do on their own. So can you give me a few examples of, and this is not to say that one is better than the other, doing it on your own versus working with a trademark attorney, but can you give me some examples of things that often go wrong when that you've seen go wrong when people do it on their own, reasons why an application could be rejected?
Yeah, there are, I would say that the top three are you submit what's known as a bad specimen. So in order to get a trademark registered in the US, generally you need to show the Patent and Trademark Office evidence of your use, whether it's a screenshot of, a platform showing the title of the podcast with the various episodes under it. But you need to say, hey, we're using this mark in connection with our, podcast services. Sometimes the specimen isn't good, and the PTO will kick it back to you and say, we need another specimen. We reject it. A trademark attorney can easily identify a proper specimen and avoid that kind of refusal. Excuse me. The second is identifying the wrong applicant. This is very important and can be a fatal error because if the wrong applicant is identified in an application, that application is what we say void ab initio, which is Latin speak for it's dead at the beginning. You can't fix it. It's just dead. So let's say you file it in the name of an LLC, but that LLC didn't exist when you filed the application. You hadn't set up your organization. That application is dead. So a trademark attorney can advise you on when to file if you want to file under, an entity that doesn't exist yet, or who right now is the proper applicant. And third is getting the identification of goods and services correct. Um, the PTO, Patent and Trademark Office, does not offer a lot of guidance for applicants who file on their own on that front. So, a trademark attorney can say, draft a very quick recitation of services for you that works, make sure it accurately reflects what you're doing. And trademark attorneys also have the expertise to give you the broadest scope of coverage, as we say. So you want to be able to enforce your mark against, a broad range of people. Um, you know, Instead of just podcast services featuring, legal topics, you would just say podcast services. Then you can cover every podcast. And the trademark attorney can advise you on strategically identifying the goods and services that will help you best.
And these are the different classifications or categories that
Yes.
you're specifically filing for.
Yeah. And actually that's a really great question. It kind of folds into a question that we just got about whether a trademark in the US prevents podcasts in other countries from using that name. That's a great question. And I should have said this at the beginning. My trademark advice right now pertains to US trademark law. I work with other attorneys to work on trademarks in other jurisdictions, but trademarks are geographic in nature. Generally, if you're using it in the US and only using it in the US, your trademark rights don't cross a territory. Like, you can't go into Canada if you're not offering the services in Canada. So my answer to that question is, do trademarks in the US prevent podcasts from others? It depends. Are your podcasts available in other jurisdictions, or is the distribution just only in the US? It would require a little bit of digging to see which people have access to it, to see whether or not your rights extend outside of the US. So that's the lawyerly answer. It depends, but generally you should assume that if you're mainly focusing on the US, your rights don't extend outside the US territory unless you're clearly targeting another jurisdiction.
I would imagine, though, as somebody without any sort of law background, that doing the more legwork that you do up front, the better positioned you'll be to take on any potential legal challenges in the future, no matter what.
Exactly. Yeah. You always want to be forward thinking in selecting and adopting a trademark, whether it's the name of your podcast, the name of your business, to see if it's going to extend, several years. Do you want to invest in that mark a lot? Maybe you want to register it. And, you might think, okay, I want to be working with podcasters from all over the world. So do I want to think about whether or not I'm going to file in other jurisdictions like Europe or Australia or in a country in Asia? That's something that you do need to think about, and a trademark attorney can kind of help you get your ducks in a row to set you up to do those filings.
Could you share a bit about the timeline for this process? So from when somebody first engages with you through when their trademark might be, could potentially be filed?
Yeah. Excuse me. So the application process, getting the application on file, generally doesn't take too long. Initially, we recommend trademark clearance, which is, generally it consists of a thorough search of the patent and trademark database to see if there are any registered marks or pending applications that might pose an issue. They might be conflicting. Either they're exactly the same or they're concerningly similar. And you also take a look at the internet to see if anybody is using but hasn't applied to register or registered the name of a podcast. And if you see any conflicts, then you should generally consider selecting and adopting a new name, start again. If everything looks good, then you can get an application on file. It can either be a use-based application, so you've already launched the podcast. Hooray, you submit that specimen that I talked about, and then you wait. You wait about 10 to 12 months for an examiner at the US Patent and Trademark Office to examine it. This process is the same for an intent to use application, except you don't submit that specimen because you're not using the mark yet. After that 10 to 12 months, it's examined. On the rare chance that everything looks amazing, it just flies through. If that doesn't happen, and it's usually the case, like 88% of applications get some sort of initial refusal, be it a non-substantive, like, hey, we don't like this wording in your identification of goods, or there is another mark that's conflicting with yours. It runs the gamut. But generally, you'll get some sort of office action. You'll have 3 months to respond to that with the option to extend that for 3 months. You take care of that. Everything looks good. Then the application proceeds to publication, which is a 30-day period in which the public can take a look at your application and decide whether or not to oppose it. Meaning, no, we don't want this to register for these reasons. And that's outside of the scope of this conversation, the opposition process, but let's assume no oppositions are filed, happy days. If you filed a use-based application, that registration certificate will issue in about 3 months. If it is an intent to use application, what's known as a notice of allowance will issue. And that is a little piece of electronic paper that says everything looks good. All you need to do is submit your evidence of use. You have 6 months. After that 6 months is up, you can either file your statement of use or say, I need a little bit more time. Give me 6 more months. You have 5 6-month extensions. So you have 3 years from the date the notice of allowance issues to when you need to put it into use. You have a lot of time. You have about 4 years in total from application filing date to when you need to show use to the United States Patent and Trademark Office. So that's why filing an intent to use application is so beneficial, because you get your flag in the hill. You say, public, I'm going to use this mark on my podcast, don't use it. And then you have a little bit of breathing room to put that into use.
So that's what I was going to clarify. That just because you have an intent to use application in, and you might need to wait 7, 10, 12 months for the application to be filed and hopefully approved, that doesn't mean you need to stop what you're doing. And in the meantime, you can continue right on producing this, right?
Right. Not only can you should, because a requirement of filing an application based on an intent to use is to have what's known as a bona fide intent to use. So you have to have some plans to put the mark into use. One of the grounds for third-party challenges, particularly of intent to use applications, is lack of that bona fide intent. You can't just file an application as a placeholder. You actually have to have plans to use it. So if you come up with a really great podcast title that you're like, this would just be a really cool name, we're not really going to use it yet or have any plans to, I highly recommend, although this isn't legal advice, I highly recommend against filing an application because it's vulnerable. Once you start putting together that business plan, that proof of concept for that podcast production, then you can start considering getting an application on file. But just because you have a cool name doesn't mean you have the right to file an application.
But you do have the ability to renew or extend your application. So, and this may not be pertinent to anybody, but after that 3 to 4 year period where you've renewed, are you then not allowed to go back and reapply after that? Or do you just have to go through the application process again?
You just have to go through the application process again. And I've done this with a couple of clients in that they just haven't gotten the funding, they haven't been able to get the project off the ground. So like just before the initial application dies, we get a new application on file, so there's no gap. And that's been a good strategy for them because they finally got things off the ground in the second or maybe the third one. But sometimes these things can take time. It's, it's not an inexpensive venture. Um, and uh, it can get expensive because every time you do extend, there is a filing fee. And if you do have an attorney, you have to pay the attorney's fees associated with it. So that's something you want to think about. And another reason why you really want to make sure you have the intent to use that trademark, so that you don't have to spend so much money after that notice of allowance issues.
Now, what about for folks who might be in a position similar to mine, where you have this proof of concept, you're pitching it to some networks, you have your intent to use application filed, you've got your digital paperwork that says all of that is good to go, and then a network chooses to partner with you on this, and you've got a contract with them. You as the creator in the theoretically still own this trademark as part of this deal, all hypothetical. But then 2 months later, the podcast launches. What step do you have to take you have to file more paperwork then, correct, to let the patent trademark office know that this is now something that's live, essentially change the status of your filing to let them know that this is now out there, correct?
Yeah. And the filing you make after the notice of allowance is called a statement of use, um, where you submit the specimen and then you submit a declaration saying, I declare under penalty of law that this is in use. Now, the fact that it's an intent to use application, I should note, doesn't prevent you from filing a statement of use or an allegation of use, before the application is examined. So if you were to launch your podcast next week, you could let me know and I would get an allegation of use on file for you. So that would become a use-based application once it gets to an examiner. And that's a way to kind of speed up the process for you.
Great, thanks. That makes sense. So I want to talk a little bit about the costs associated. So first, just the standard rates for going about this process yourself, because I know that there are fees that no matter where you live in the country, these fees are universal. And then after, I want to talk about the costs associated with working with an attorney, which I know can vary a whole lot more. So could you share with the attendees what costs are associated with going through this process yourself?
Yeah. So I should put everyone on notice that as of January 18th, 2025, so in 8 days, a whole new fee structure is going to be in place for the Patent and Trademark Office. And this is something that we are grappling with because we've never had a fee structure like this. Um, and I'll explain, very, sounds like gloom and doom. But let me explain what the fee structure is right now in case any of you are interested in filing before January 18th. So as it stands right now, there are two types of applications you can file. One is called the TEAS standard. TEAS is Trademark Electronic Application System. There are a lot of acronyms in the government. The Trademark Office is not immune from that. That is $350 to file. And it allows you to, one of the biggest benefits of this application is that it allows you to write what's known as a free form recitation of services. So it gives you more leeway. You can have a broader scope of the goods and services you're offering. And you don't have to disclose certain things up front. Like, let's say your name is in the podcast. It's the Adam Flaherty Show.
Great name,
You don't
by the
have
way.
to say, yeah, I'd listen. You don't have to say, my consent is of record, something like that. that will be down the road when the examiner sees it. Because in patent and trademark world, you need someone's, if your podcast contains or your trademark contains the name of somebody who's living, you need to have their consent on record. You don't need to file that up front with a T standard. With this other type of application, a T plus, oh, did I say T standard is $350 per class. For trademark filings, and this applies to every jurisdiction in the world, goods and services are categorized in different classes. Podcast services are in class 41, which is where entertainment and educational services are. If you have, branded swag, that would be in class 25 for apparel. If you also offer, consulting services for fellow podcasters, that's in class 35. It all depends. So the more classes you have, the more expensive it is. So if you file a single class application just for podcast services, that's $350. If, on the other hand, you file what's known as a T's plus application, that's $250. You would need to, provide additional information, such as a translation or transliteration, consent of a living individual, and you can't use that free form box. The Patent and Trademark Office offers some pre-written IDs, as we call them. So it'd be like podcast services and the nature of, and then you fill in the blank there. But you are constrained by what the PTO has. And sometimes you kind of have to, shoehorn in what you're doing into those IDs to get that $250 per class fee. So those are the two kinds of applications. As a trademark attorney, I generally file 350 T standard, unless it's like we're selling shoes and that's all we sell. Then we can do that. Otherwise, it just gives you more flexibility. As of January 18th, that's going to change. There will be only one application, which is $350 per class. And every application, let me start. The USPTO is now charging surcharges if you don't provide additional information like that consent, like that transliteration or translation. Also, you get charged $200 if you decide to use the free form ID box instead of using the PTO's pre-generated language for your goods and services. You also get a $200 surcharge per class if you exceed $1,000 words, characters in the freeform text box. There are a lot of places where the fee can quickly go from $300 to $1,500. No, wait a minute. I can't add right now. It can increase by $500, so $850.
We won't judge you on your math, but I'll say, like, everything that you're saying right now, Becky, for me personally as a creator, is the justification for why you would want to work with an attorney who's, again, gone through this so many times, because those are all errors that I would make, and suddenly it would go from $350 to over $1,000, and I would have no idea why, and it would prolong the process and quickly get expensive. So thanks for that explanation on potential costs. The other piece of that is, obviously people a lot of times have this idea in their mind that, working with an attorney is going to be really expensive no matter what. And can you share a little bit of insight into what kind of time and costs from your end go into working with somebody through this process?
Yeah, I can't speak for all firms, but I would say the majority of trademark practice groups charge fixed fees for preparing an application, for preparing a statement of use. for preparing these standard filings. So the quote you get from that attorney will be exactly what you're going to see. There's not going to be an hourly rate. It'll just say fixed fee of blank. It ranges widely. There are some very small firms or some, not to be disparaging, but I am going to be disparaging, trademark mills that, there are attorneys that are filing, but they don't offer you the services of, person to person that are very inexpensive and say, oh, we'll file your trademark application for $300. Always be wary of that because you're not going to get strategic advice. That's just my personal 2 cents. But, it likely ranges between, $1,100 to $1,500 for a single class application. And it usually goes up the scale the larger the firm you go to. But most firms do have a fee schedule, and you can say, hey, can you send me your fee schedule? And then you can take a look. Nothing should come as a surprise in terms of fees for filing an application, unless something completely insane happens. That should be something like, our fees are this, the filing fees will be this. There you go. Budget accordingly. For hourly work, that also ranges. And for hourly work, I mean, let's say you get a refusal, that response will take time, and that will take time from the attorney. That is generally charged at the attorney's hourly rate. You'll see some firms, usually solo or very small practice groups, offer some sort of office action package, like $750 for the first refusal. I would be shocked that, a very substantive office action response would be that inexpensive. But again, consult with that attorney, consult with whatever attorney, you jive with, which you think will advise you the best, and go with your gut. But the fees will definitely range, and you need to be prepared, particularly if in the clearance process, certain potential problems were identified. Like you might have to address this in an office action. You might want to set up some sort of war chest. So set that money aside, be prepared to spend money if that's what your attorney advises, because if you really want that trademark registration, it can be an investment. So
yeah, and working with somebody one-on-one like Becky, I had the ability to ask her up front before we started doing this work, can you give me an idea of what these costs are? And so I knew going into it what the investment was going to look like. And if it was more than I had budgeted for, or it was outside of my comfort zone, I'm sure she would have guided me to go through this process on my own. So all that to say, look for transparency with whomever you choose to work with. I have a couple of other questions that hopefully are quickies, because I do want to leave a little bit of time for some of the questions that have come in. One of them connects back to something that we talked briefly about earlier, which is, what if there's a conflict? So let's say a podcast creator, they did some research, they did some Googling before of their podcast name before they launched it, didn't find any conflicts, and just said, okay, let's do this. They publish their podcast, maybe they're 6 months in, 12 months in, they've seen some success, and maybe have some sponsors, and have a large audience, and have a bunch of episodes, and then receive a cease and desist in some form, whether it's through DM on social media, through email, a letter in the mail, I don't know. Can you share, what would you recommend that somebody do if they were to receive something like that?
Don't panic. First of all, also don't ignore it. Those are the two things. Don't panic, don't ignore it. My other answer is it depends. It's always scary to be on the receiving end of a letter, regardless of whether or not you're fine, like you have priority or there's no likelihood of confusion. It is never fun. So read it thoroughly and talk to your business partners, and then call an attorney. Um, I really do recommend seeking like very limited counsel. If it's something like I just need a gut check from an attorney, is this something I can say, hey, pound sand, I've been using this for longer than you, or, you know, you're in a completely different marketplace than we are. Nobody's confused us, but talk to an attorney, because the last thing you want is to ignore it. Say pound sand when really they have a case. But get some expert advice, whether or not it's, you know, super in depth or just like, please give me a gut check. And you can tell that to the attorney, like, I have, $300 to spend on your super quick assessment, but be very upfront and say, like, look, I'm willing to invest blank amount of money in this assessment. Can you do that? If not, refer me to someone. But you generally want an attorney to take a look at it, particularly if it's from on law firm letterhead, because they've already invested in counsel to write this letter to you, and they made that investment. They might invest in further action. After that, it kind of really depends on the situation. Third party conflicts are very much assessed on a case by case basis. It could be that there's a lot of dilution in the market, and there are, 12 other podcasts with similar names. You all can coexist together, or you're the only two podcasts out there and they've started using before you do. How do you negotiate something so that you can get out with the least amount of damage? It's something that you really want to consider with, strategically with an attorney. So answer is, it depends. Talk to an attorney.
And I know just from having chatted with you about this before, in the event that they are correct and they've already had this established thing and you somehow just missed it, a lot of times you're able to negotiate a sort of grace period where you might have a period of time. You don't just have to shut everything down.
Right.
You can negotiate a period of time where you can migrate, over to a different name, a different word mark, if that's the case.
Yeah. Generally, people are generally pretty amenable to that. You're like, look, we need a phase out period of 6 months to be able to inform our listeners, to be able to update our name on all the different platforms, and to educate people of our new name. So, so long as you're, complying with everything else, it shouldn't be an issue. 3 to 6 months is generally the standard. I usually always start with 12 months and have them ratchet it back, but why not ask for something and see if they give it to you?
Great.
Yeah.
The last thing that I just wanted to say, and it's more of a warning to folks as opposed to a question for you, although anything that you want to add to this is great. Becky did warn me early on in the process that after you get this filed, even just the intent to use is filed, that you may get mail, like actual physical mail, because a mailing address is made public. That is essentially scams. And I've gotten 3 letters in the mail that look like real legitimate invoices from companies that purport to be like podcast or not podcast specific, trademark directories, and the invoice amount, what they're requesting from you, really closely matches the filing fee. It's all intended to mislead you. If you look at the fine print, it will say this is a solicitation. You're not required to pay this, but I think that they're preying on people who aren't looking at those fine details. So just be aware that if you do go through this process, you may get a few pieces of spam, scam mail, and you should definitely avoid them. Throw them away. If you have any questions about them, you can share them with your legal counsel just for a gut check, and they'll tell you to put them in the shredder or the recycling bin.
Yeah. The patent and trademark office is purely electronic. The only thing that they send via letter is nothing now. Actually, they don't send anything. So the PTO also does not send invoices. So a paper invoice is completely fraudulent. It's a scam. Do not fall for it. Another scam that's been occurring recently is, excuse me, it's email related, and there are these, uh, I hesitate to call them firms, um, legal organizations that email trademark holders and say, I have a client that I just did clearance research for, and we just came up with your mark. We're going to file it in 2 days unless you ask us to file it for you. They're trying to get your money. Generally, you pay them and nothing happens, and they just go away. Or you pay them and it's a really shoddily filed application, but just delete that. Do not pay attention to it. They try to make it look legitimate, and they cite completely improper trademark law. Just say
Thanks.
no.
Thanks for thanks for that warning. Becky, are you good if we jump into a couple of the great questions that have come through?
Definitely.
All right. So Anna is asking, if I'm filing a trademark for my company, which was registered as an LLC in Texas, but I moved to Arkansas, do I need to file it based where the LLC was originally filed, or the new state, or both?
Great question. That is actually a question for corporate counsel. Which LLC is the one? Well, corporate counsel, because which is the one that's going to be kind of the one that is properly running the business? Is it going to be the Texas-based LLC that's going to be running that business and holding the trademarks? Or is it going to be the Arkansas LLC that's, running the business, operating the business, and holding the trademarks?
Great.
So it wouldn't be both. I will say it will be one or the other.
She had a follow-up question. According to what I think I'm understanding, if my company and podcast have the same name, I would need to file 2 separate trademarks. Is that accurate?
No, actually, you can file one trademark application, claiming various services. So you could have, podcast company name, and in the application, you could identify, the podcast services for the podcast that is under it. And then for your company, it could be like podcast production, consulting services as well. It can be all filed in the same application to keep it nice and clean.
Great. We have a question from Kira, which says, would it only apply to other podcasts? What if someone wanted to start a newsletter with the name of your trademark podcast?
It depends. It depends on whether it's in the same, subject matter. If you have a podcast on, medical miracles, perhaps, and this is the same name of a newsletter on medical miracles or something medical related, then yes, there's conflict. Likelihood of confusion is the legal term for that kind of conflict between trademarks, is determined based on 2 primary factors. And that's the similarity of the names, and very importantly, the similarity of the goods and services. Because trademark rights extend only to specific marks in connection with specific services, which is why you have Delta Faucets, Delta Airlines, and there was another Delta, I can never think of it. But you can have those 2 Deltas coexist without any sort, Delta Dental, without any sort of problems, because those services are so disparate that no one would be confused. No one would think that an airline is going to do your, teeth cleaning. So podcasts and newsletters, it depends. Because they're kind of in the same, providing the information, if they're identical, and I can't speak in hypothetical. It depends. It could be.
It seems that if there was a podcast, we're talking about not an entertainment podcast, but maybe a marketing podcast, and your newsletter was a marketing newsletter that is, and you want to name your newsletter something that shares a name with this marketing podcast, it would be in your best interest to not, because no matter what, you're going to be setting yourself up for more work in just letting people know that these are two different things, right?
Right. And, that's when the issue of priority comes in. Like if you started off, like if you launched your podcast before this newsletter came out, you can say, hey, newsletters, stop using it. You're infringing my rights. Because there's, a likelihood of expansion from a podcast into a newsletter. That is something that happens very frequently, that a podcast will have, a regular newsletter for its listeners. It's not outside the realm of possibility. So you can say, look, you're in my business, you're in my area, please stop using it. I'll give you, a couple months to stop using it, but we want to launch um, our own newsletter and you're infringing our rights. So please stop.
Great. We've got a couple minutes left. I'm going to put you on the spot. If you don't have a good answer for this, don't sweat it. I'm curious if there's any, like, what's the craziest trademarking story, pertaining to podcasts, if you have one, something that you're like, I never would have guessed that this conflict would have happened, or never would have expected this in someone's podcast trademarking journey. Can you think of anything?
Not for podcasts, but I do have a kind of a cautionary tale. Um, so, and it's about, the big businesses that might go after you. Um, is I know no one can really answer me, but is anyone familiar with how Apple acquired the rights to iPhone? So there was a company out there that had a registered trademark for Apple, geez, for iPhone, um, for, very, that's those services for some sort of mobile telephone. Apple said, damn the torpedoes. We're going to call our product iPhone and we're going to take this guy down. So they did. They filed an application for iPhone. They, I don't want to say they stole, but this guy fought and fought and fought, and they finally got it from him because they paid him enough money. But that can happen. Large companies do sometimes just go in, they say, we're going to do, we're going to adopt this mark regardless of what 30 parties you're using it. And because we have, you know, deep, deep pockets and we're going to go after them. You can always say no, but it's a fight. Yeah. I know that's not
That's
like super crazy, but
yeah, no, I mean, it's a great anecdote to share with viewers who might be considering the process. Is there anything that we haven't talked about that you were expecting to share, or that you think would be valuable for people we haven't touched on?
I think, you know, regardless of whether or not you're going to register your trademark, some best practices are to just make sure you have your first use date documented. That really helps in third-party disputes where someone's saying, I used first, and you say, no, this is my date of first use. Just make sure you have that documented somewhere. Also, just make sure you keep an eye on the domain space as well. There are a lot of, domain squatters that might find a great name and, register that domain and try to exploit, get some money out of it. I had a client who filed 2 trademarks recently, and that very day that they appeared in the public trademark database, the same third party filed domains for those marks. So that's happening more frequently. Be careful of that. Maybe register the domain to your podcast while you're kind of gearing up to launch it, because that's a space that, can make you vulnerable as well. Also, any resources you can recommend for us to start registering our trademark. The Patent and Trademark Office, despite what I said about not offering a lot of resources for the specific goods and services area, they do have some good webinars for pro se filers that do give you an idea of like just the background of trademark law, how to prepare an application, what is the first use date, why are there two separate use dates in the application. So start with the United States Patent and Trademark Office. Also do kind of a Google search, because there are some, solo practitioners that are really good at providing educational material on YouTube that can give you like a really good quick rundown on kind of how to go about the process. The PTO did just adopt a new application form, which practitioners are still getting used to. I need to learn it, to be perfectly honest. Our paralegals are getting used to it, but you'll probably see some tutorials come out about that too if you file after the 18th.
Excellent. Becky Lessard, thank you so much for sharing this like wealth of wisdom with us. Thank you to the Podcast Academy members who joined live for the webinar, and to everybody watching on YouTube. Becky, we'll make sure that your contact information is in the video description if people want to reach out to you with questions. And thank you so much, everybody. This has been awesome.
Thank you very much for this opportunity. It's been fun to nerd out to all of you. Thank you.